We're going to talk about probate today. It's going to be quite a sort of an introductory sort of broad approach. So we'll try and touch on everything a little bit, but obviously then it won't be as in detailed in any one of the areas as it might otherwise be. A very quick roadmap. We're going to start off with a quick introduction. Then John is going to take you through a sample will that he's prepared with the kind of common clauses that you'll see in most wills or in a lot of wills. Then we'll touch briefly on intestacy, so what happens when someone hasn't left a will. And then we're going to jump into the issue of contentious probate claims. So it's going to be essentially where someone wants to complain about or challenge the conduct of the executor. Secondly, where there's a dispute as to how the will should be interpreted. And then finally, the validity of the will. Now, the validity of the will would be the most the meatiest section, because within that we'll also have disputes as to whether someone had mental capacity in order to make a valid will. Secondly, whether they had the requisite knowledge and approval to make a valid will. And finally, whether there was any undue influence exerted on them in making their will. So, we're up to 60 now, John. Okay, so yeah, brief introduction. Last will is so someone can obviously make a number of wills throughout their lifetime. The last one is the only effective will. It's important to remember that marriage or civil partnership automatically revokes a will. And finally, that divorce or annulment does not revoke a will, but the ex-spouse or ex-partner is treated as having died on the date of the decree absolute, which is quite important to remember. So it's important to remember also that executors, they're not trustees. They're quite similar to trustees. They have fiduciary duties. The assets vest in them legally and beneficially on death. Although in some cases they may need to apply for a grant of probate. And if there is no executor, so if someone either hasn't left a will, or if the executor has died before the testator has died, then the estate will vest in the public trustee pending pending distribution of the will. John's going to take us now through this sample will that he's prepared, so I'll just try and change the screen to show that will. All right, John, can you see the will now? Is that working?
Yes, thank you. Right, morning everybody. Now this is a very simple will. Apologies to those that know all about the drafting of wills and so forth, but there may be one or two of you who need just to get a roadmap as to what's in a will. As Conor has said, what we're looking for is the last will of a testator. So the first clause will usually be a revocation clause of other wills. And then there is an appointment clause dealing with the appointment of executors. I know there's one question that somebody has asked, just dealing with the appointment of executors. If somebody who is named in a will as an executor and doesn't wish to be so, there is provision whereby an executor can renounce his or her executorship. So although you may be named, you don't have to take on the burden of being an executor. Another way round the problem, if you think there is a problem, is if there are two or more executors, one could deal with the probate, the other, being an executor, could have what's called power reserved, so still remain an executor, but not be the person who primarily carries out the duties of the executor. That person, taking a power reserved, could take a back seat, but still have the office of executor. Now you'll see at clause 2.3 that the executor has been named also as a trustee. That is common where there are trusts in the will, and the executor in that position will be treated as a trustee. An executor, just simply as an executor, is not a trustee. Then there are funeral directions, appointment of guardian, and then there is a bequest of money. Now, the bequest of money, sometimes money bequests are known, or generally known as legacies, but this is a matter of terminology. It's a bequest of, then a bequest of chattels, and a further, at clause 7, specific request, a bequest of one particular chattel, namely a grandfather clock. Now, once the legacies and bequests have been distributed, there then remains what is called the remainder of the estate. And the clause 9, one sees that there are provisions as to how the remainder is to be distributed after the payment of debts. I know there was a question about some payment of debts, that there is no particular priority of debts set out, except where there are insolvent estates. But generally speaking, any debt that is secured will clearly have to be paid out of the security. First and foremost, out of the estate must be paid the funeral and testamentary expenses. And once those have been paid, and as I say, the legacies and bequests have been made, the residuary estate, that is the remainder, is to be used for the payment of the debts. And the residuary estate there is given to the widow at clause 10. There are then substitutional provisions, so that if, for instance, the beneficiary of the residuary estate were to die, then the gift is then to go here to the Battersea Dogs Home. So you'll commonly find default provisions in the will, and if you're drafting a will, clearly they have to be carefully drawn, because if they fail, then there may be an intestacy as to that gift. There is a declaration about Section 33 of the Wills Act. Section 33 is a default provision. In effect, if one of the beneficiaries were to die, Section 33 says that the gift is to go to their issue. But here it is being disapplied. Most importantly, there is the attestation clause, and a will is not valid unless it is signed by the testator in the presence of the witnesses. That's very important. When the witnesses come to sign, each must sign in the presence of the testator, but needn't sign in each other's presence. So the important thing is the testator signs in the presence of both witnesses, but each witness, provided that they've signed and witnessed the signature of the testator in the testator's presence, needn't sign in each other's presence. Now, there's been a modification because of COVID to the provisions about signature of witnesses in the presence of the testator. Clearly, because of COVID, there are cases where it's not possible for the witnesses to be physically present. So under the Wills Act Electronic Communications Amendment Order, which came into force last month, it is now possible to witness the testator's signature by a video link or some other similar means. And this is partly retrospective. It applies to wills made since the 1st of January this year, and will apply to wills up to January 2022. So partly it's retrospective. There is an argument, which I won't go into, that might be unlawful, but I doubt it. But it is important to remember now that a will can be validly executed by means of a video link. And the Ministry of Justice and the Society of Trusts and Estates Practitioners, each of them have issued guidance which is available online as to how to deal with the execution of wills by video link. And if you do find yourself having to deal with execution in that way, it's a good idea to have a look at that guidance, as I say, available online. Now, if there's no will, there will be an intestacy, and the administration...
Hold on, Joe, we've just had two questions.
Yeah.
What's the difference between a beneficiary and trustee in relation to property house?
In relation to?
A property?
Well, the will nominate as executor, perhaps also a trustee. The executor is not a beneficiary necessarily. The beneficiary is not necessarily an executor. So the two offices, so to speak, certainly the office of executor and beneficiary, can be distinct people, and in many ways, and usually are. But the beneficiary does not have any title to the estate. It's on the death, it's the executor that has the title to the estate. All the estate devolves on the executor. All the beneficiary has is an expectation that the estate will be validly administered and duly administered. And it's not until distribution that the beneficiary acquires any title to any property in the estate.
Yeah, that's an interesting distinction. So a beneficiary under a trust will have a beneficial interest at equity, whereas a beneficiary under
will.
Yeah, a will, or even after the death of the testator, doesn't actually have a beneficial interest in the property.
No,
yeah.
Not until distribution.
Yeah. And then one more question: does succession forfeiture have any impact on wills?
Does
succession/forfeiture have any impact on wills? I think
I'm not sure that there is a provision for forfeiture under the Forfeiture Act if the beneficiary, for instance, has murdered the testator. A beneficiary cannot take under a will in those circumstances. And there is an act, the Forfeiture Act, and I'm not sure whether that's an answer to the question, because I'm not sure what forfeiture means in these circumstances.
Yeah. Okay, thanks for that, John. So yeah, moving on then to intestacy, which is what happens when someone hasn't left a will. So it's dealt with by the Administration of Estates Act, in terms of that sets out the distribution. It's almost like a sort of a tree diagram whereby, well, initially the estate vests in the public trustee, And then usually there'll be an administrator appointed, usually a family member, a spouse or something like that, who's in a good position to administer the deceased's estate. The order of distribution is set out in the Non-Contentious Probate Rules 87. So initially the lion's share, or all of it up to a certain amount, goes to the surviving spouse or partner. I can see someone's raising their hands. Just if you missed it at the start, the way to ask questions is in the Q&A box. There should be a Q&A box. You can type that in, and then I'll check it periodically, and we'll try and answer any questions that are asked. I think that the hand raising thing doesn't work as well. Okay, so going back to the order of distribution. So as I was saying, the surviving spouse or partner gets the lion's share up to a certain amount. If there's more than that fixed amount in the estate, then an additional amount will go to any children, so sons or daughters. If there are no sons or daughters, then the next, no spouse and no sons or daughter, then the next person who will inherit are parents if they're surviving. If there are no surviving parents, then brothers and sisters, and so on through more distant relatives until there's no one to inherit the estate of the person who didn't leave a will, in which case it goes to the Crown. Do you want to take this bit, John?
Sorry, yes. Traditionally, by English law, a testator can leave his or her estate to whomever he or she pleases. There is freedom of testation. That's circumscribed particularly by the Inheritance Provision for Family Dependents Act, the successor of an act in the 1930s. So that if certain classes of relation of the testator or a dependent of the testator feels that the will or the rules of intestacy, if there's no will, do not provide adequate provision for that person, they can apply to the court for reasonable provision. Reasonable provision depends on whether or not you're a relation or a dependent. For instance, if you're the widow, reasonable provision means what you would have got if there had been a divorce, broadly speaking. Whereas if you're merely a dependent, reasonable provision means reasonable for your lifestyle and your needs. You must make an application within 6 months of probate being granted. So there is a time limit, and it's important to keep to that, although under the Act there is a provision for extension of time. But generally speaking, stick to the 6-month time limit.
Okay, so moving on then to challenges to probate, so contentious probate. It's the rules and procedure for these claims are set out in CPR 57, so that's where you'll start. You can challenge three different generally three areas. First, the manner in which the executor or administrator is carrying out their duties as the personal representative. Second, if you want to challenge the language of the will, so how it should be interpreted. And finally, you can challenge the validity of the will, so the circumstances in which it came to be made, as we were saying earlier in the introduction, mental capacity, undue influence, that sort of thing. So John's going to start with challenging the conduct of the executor.
Yes. As I've said, the personal representative is not, and by that I mean either the executor under a will or the administrator under an intestacy, is not, by reason of that office, a trustee, but they do nevertheless have some fiduciary duties. Their primary duty is to administer the estate with due diligence. And generally speaking, this is very general, they have a year in which to administer the estate. As I've said, beneficiary has no interest in the property in the estate. What the beneficiary has until distribution is the right to have the estate duly administered. So if the administrator or the executor is not, in the view of a beneficiary, carrying out his or her duties with due diligence, the beneficiary can apply to the court to have the executor perhaps pay debts more swiftly, or get in property more swiftly. But other than that, the beneficiary has a very limited interest. He is entitled to an account and an inventory of the estate. And if the personal representative is behaving negligently, then the personal representative could be personally liable to the estate for any damage that's caused, and that's known by the Latin term devastivit. The executor also, if he or she is uncertain as to how to proceed with property in the estate, either all of it or some of it, or has any particular query as to perhaps the payment of a debt, the executor can apply to the court for directions. And that is a safeguard for the executor, because of course, if there is a court order allowing the executor to behave in a certain way, or to administer the estate in a certain way, then there will not be any claim for negligence against the executor on that account. Further, there is power for the court to relieve an executor of liability if they have acted honestly and reasonably.
So, John, just to interrupt there, someone, Elisa Kubik, has asked a good question. Where there's a will, is a grant of probate required to be able to act on behalf of the estate in a personal injury or clinical negligence claim?
Yes, generally speaking, taking proceedings, you'll need to have a grant of probate. You might also have to apply to the court for permission to start an action, because of course what is happening is that you're incurring costs to the estate, and one can have what's called a beddoes application to the court to sanction proceedings to be taken by the personal representative.
Okay, thanks, John. I can't remember if you'd mentioned this. I think you were finishing up on applying to directions for personal representatives or insurer about what they should be doing. I think something we discussed previously as well was they can find it very useful to know that they can have beneficiaries insurance. So if anything does go wrong, although primarily they'd be liable in their personal capacity for devastivit, they would then be covered with insurance. So that's very useful.
That's particularly so if, for instance, the testator has left property to a class of persons, say to all of my nephews, and you find that there are in fact five nephews, but you can find only 4. You can't find the last one because perhaps they've emigrated. Then you can take out insurance to, if, or perhaps you're unsure as to whether that person has died, you can take out beneficiary insurance to cover you if in the end you distribute the estate to 4 nephews, and then later on the 5th one pops up and says, where's my money? So it's a useful thing to bear in mind, that insurance. Otherwise you would apply to the court for directions as to how to distribute the money
Yeah,
to the nephews.
just one more question from Sushil Gill. What is the position regarding breach of trustees' duties regarding will trusts? So I think that must be where a personal representative acts in breach of trust.
Yeah. Well, if there's a wills trust, then the executor will be named as a trustee,
Yeah.
and as a trustee has all the duties of that position, and so is liable for breach of trust if those duties are unfulfilled.
Yeah.
So it will be a straight action for breach of trust.
All right. Thanks for that, John.
Now, another way to challenge the executor, if you feel that an executor is simply not up to the job or not doing the job at all well, there is a power on the application of a beneficiary or perhaps another personal representative to remove the personal representative, an executor, and to replace that executor, perhaps by a professional such as a solicitor. And similarly, where there is an intestacy, there is power under the Senior Courts Act, section 116, to replace an administrator before the grant, and a beneficiary under the rules of intestacy might wish to do that, but there have to be special circumstances, and the court has to be satisfied that it is necessary or expedient to appoint an administrator in the place of the administrator who is there by virtue of the non-contentious probate rules, Rule 22.
Right. So thanks for that, John. Turning to challenged in the terms of the will. So this is Lord Neuberger in Martin and Rollins. In a nutshell, he says it's the same as when you're interpreting a contract or other such documents. So the usual stuff about natural and ordinary meaning of the words, the overall purpose of the document, facts known or assumed by the parties at the time the document was executed, and of course, as with contract, ignoring subjective evidence of the parties' intentions. So just limiting the interpretation of the will to what's on the document, and not admitting extrinsic evidence about the parties' intentions. So yeah, as with contract, to identify from the will the intention of the testator. Do you want to take this bit, John?
Sorry. Yes, another way in which the, if you're going to challenge the will, you could use Section 21 of the Administration of Justice Act, which applies insofar as any part of the will is meaningless or is ambiguous. In that case, generally speaking, with contracts, one cannot use, in interpreting the contract, evidence as to the actual intention of the parties, outside evidence. But by Section 21, the court can take into account evidence of the testator's actual intention. And other extrinsic evidence, including that intention, in order to interpret what the testator meant. But it is only where the will or any part of it is meaningless or ambiguous. Only then can you use extrinsic evidence. So, and the court can also rectify a will. But again, only in limited circumstances, only if there is a clerical error which has been widely interpreted, or it can be shown that the drafter of the will failed to understand the instructions that were given. But again, there is a 6-month time limit for making such an application. Okay.
Right. So challenging to the validity of the will. So three ways in which you can challenge the validity of the will. First, you can assert that the testator didn't have mental capacity to make a will. Secondly, you can say that they didn't have knowledge of and approve of its contents. And third, you can say that they were subject to undue influence. Right. So beginning with mental capacity. So the starting point is where you have a will that's duly executed and appears to be on its face a rational document, the court will make a presumption that there was capacity. In that case, then whoever's challenging a will, the burden of proof is shifted to them. And what they have to do is raise a real doubt as to capacity. So they don't have to prove incapacity. They just have to show that there's a real doubt. And where they've done that, then the burden of proof shifts back to the person propounding that the will is validly made to prove that there was capacity. So this is a 19th century case, Bryant and Goodfellow. Essentially, the Chief Justice Cockburn said it's essential in order for there to be mental capacity that the testator understand the extent of the property they're disposing, be able to comprehend the claims to the property, and that there be no disorder of the mind or no insane delusion. That's slightly archaic language. The Court of Appeal looked at that again in Burns and Burns and slightly updated or modernized the language. They said the requirement is that the testator must understand and recollect the extent of his property, understand that he's giving property to more than one or more objects of his regard, and again ensure that there is no insane delusion influencing the testator. It's important to make a note. There is, of course, the Mental Capacity Act 2005. That is not the statutory test within that legislation. Is not the test that the courts will apply when it comes to challenging mental capacity to make a valid will. In the case of Simon and Byford, Lord Justice Lewison made the point that it's not to be equated with a test for memory. It's about the capacity to understand. So in that case, Lord Justice Lewison gave the example: once I knew all the dates of the kings, once I knew the dates of all the kings and queens of England, and the formula for Hooke's law, and was capable of remembering them. Although now I'd have to look them up. So of course, one doesn't need to remember all of these things. It's just whether you have the capacity to understand them, really. And then, as he then was, Mr. Justice Lewison set out the test in a helpful sort of 6-point approach. So he acknowledged that, he made these 6 points about the test. He acknowledged that since that 19th century case, our sort of understanding of mental capacity has changed quite a bit. We understand that adults with impaired mental capacity are nevertheless capable of taking some decisions for themselves if they have appropriate help. We recognize that the test of mental capacity is not monolithic, but really is tailored to the task at hand. And the key point is that context is everything. So a testator with an incredibly complex estate, someone with multiple trusts and business interests and partnerships and tax structures and so on, they're going to need a fairly respectable level of mental capacity in order to have mental capacity to execute a will validly, where the estate is that complex. Whereas in an ordinary situation with somebody has 2 children and that's it, then the level of mental capacity required to make a valid will be significantly lower. So it's worth remembering that when you're talking about mental capacity, context is very significant. So Mr. Justice Lewison then referred to a New South Wales case of Zorbas, which he thought was quite helpful. The point being made is that this isn't primarily, people usually think that mental capacity is primarily a sort of medical question. It's not. The judge in this case said, the Court of Appeal in this case said that it's a matter of common sense judicial judgment, and although evidence, well, it said that evidence from mental capacity might come from non-medical, non-expert witnesses, and indeed the most compelling evidence to show that someone had the mental capacity to understand their will would be, for example, a tape recording a detailed conversation between the testator and their solicitor, for example, going through their estate in great detail and showing that they understand what claims there might be to their estate and how it is that they've come to their decision. And then we've got Mr. Justice Templeman in Reed Simpson discussing the golden rule. So this is where there's a testator who suffered a serious illness. This golden rule that he suggested, it's important to remember it's not actually a hard and fast rule. It's rather just prudent guidance from a judge who's seen a lot of this kind of contentious probate stuff. And he says that where there is a testator who suffered a serious illness, the golden rule is that will ought to be witnessed or approved by a medical practitioner who satisfies himself of the capacity and understanding of the testator and records and preserves his examination of the finding. So again, it's not really so much of a rule as just common sense guidance. It strengthens the status of the will against any subsequent challenge, because of course if there's a doctor there to say, yes, this man or woman was of sound mind, and I conducted these tests and this is the evidence, then it's going to be a very difficult will to challenge. Sorry, before I move on, yeah. In Parker and Felgate, we had the difficult situation where someone had given instructions as to their will, and then before that point of instructions and execution of the will, they had mental impairment had allegedly supervened. In that case, again, Mr. Justice Lewison said, this is Mr. Justice Lewison discussing this issue. So he said the point is it's not necessary that the testator at the date of execution would understand the will if it had been put to him clause by clause, but what is necessary is that the testator at that point knows that he's making a will and believes that it is the will for which he's previously given instructions. So so long as he's previously given clear instructions, then it's a slightly lower level of scrutiny.
Now we'll come on to what's called knowledge and approval. And what we've done is to put up first what probate lawyers mean by knowledge and approval. In essence, it means this: although the testator might be of sound mind, and therefore the will can't be challenged on for lack of capacity, it might be challenged because the will does not, in Lord Justice Chadwick's words, truly represent the testator's testamentary intentions. That is to say, that he didn't understand what he was doing and its effect. And again, Lord Justice Lewison, who has a number of useful judgments in this area of the law, in Simon and Byerford, said this: what we're looking for is actual knowledge and approval of the contents of the will, But you have to bear in mind that it's knowledge and approval of the actual will that count. It's not knowledge and approval of other potential dispositions. And he made this useful distinction. Testamentary capacity includes the ability to make choices, whereas knowledge and approval requires no more than the ability to understand and approve choices that have already been made. So what you're, as I say, looking for is evidence, and usually it is presumed simply by due execution of the will that what the testator has written, he knows what he's written and he understands what he has written. But as was said in Hoff and Atherton, a testator can't be said to know and approve the contents of the will unless he does understand what he is doing and its effect. It's not enough he knows what's written in the document which he signs. It's, as I say, it's open to the court to infer that he does know what he's written and understands what he's doing. And if there's nothing to excite suspicion, the court may infer that the testator knows and approves its contents. It would be surprising if he didn't. So there is this presumption. But the important words are, is there anything to excite the suspicion of the court? If the court, so to speak, smells a rat and thinks that perhaps the testator didn't understand what he was doing, then it's for the propounder of the will to, that is the person trying to support the will, to overcome that suspicion. And we move on. Can you move on, Conor, to the next?
Yeah, sorry, I was just about to say we've got an awful lot of questions coming in now. I think rather than interrupting, what we'll just do is wait until the end, and then we'll dash through them. But do keep them coming.
Yeah. So traditionally, there's been this two-stage approach. It's for the challenger of the will to raise the suspicious circumstances, to say to the court, there's a rat here and you can smell it. And if the court, as I say, does think that such circumstances exist, for instance, if a beneficiary of the will has been with the testator at the time of its drafting and has suggested to the testator that perhaps the testator might like to leave the beneficiary a gift, and in essence has himself, rather than the testator, drawn provisions in the will, that will raise a suspicion. And if that sort of suspicion occurs, then traditionally the burden of proof passes to the person supporting the will to show that in fact the testator did know and approve of it. But in the Court of Appeal in Gill and Woodall, Lord Newburger, then the Master of the Rolls, thought that in a case where there had been a lot of evidence about how the will came to be executed, it might be better not to look at a two-stage approach, but simply to take the whole matter in the round and apply a holistic approach, and to decide, looking back and standing back from all the evidence, did in fact this testator understand what he was doing? And despite Lord Newburger saying that, the courts, I think, will tend to adopt a two-stage approach and then might check it by standing back. But in a case where there's not much evidence, I think probably the two-stage approach, which is fairly embedded, will continue to be used. And Barry and Bufflin gives really the origin of the two-stage approach, and gives the example that I've given. If a party writes or prepares a will under which he takes a benefit, that's a circumstance which ought generally to arouse and excite the suspicion of the court. And it calls upon the court to be vigilant and jealous in examining the evidence in support of the instrument, and shouldn't and ought not to pronounce in its favour unless the suspicion is removed and the court is satisfied that the paper does truly express the true will of the deceased. Because one always bears in mind that the word will is what it means. It is the testator's will. It's what he wanted. And that's what the courts are ultimately always after. And Fuller and Strum again, one sees that the suspicion may be aroused in varying degrees depending on the circumstances. And so the standard of proof that's going to be needed may vary. It's always going to be the civil standard, but the sort of evidence that one needs might vary in terms of its how compelling it is, given the particular facts. And again, there is the two-stage approach. And we come then again to the example most common of a person who is a beneficiary being concerned in giving instructions for the will. That's the main scenario in which you'll find that knowledge and approval is challenged. Can we go on to the next slide? Because I'm conscious of time. Again, at the end of that quote from Fuller and Strum, one sees the presumption that the court generally makes. Where a will has been duly executed by a deceased of testamentary capacity who knew he was making a will, and it's shown to have known and approved of a specific part of the will, the court must consider how real is the possibility that the deceased did not know and approve of the remainder of the will. And that requires a careful examination of all the circumstances, including the directions and dispositions of the will. This is a case that Lord Justice Chadwick had in mind, where it may be only some of the dispositions, or even one disposition, could be challenged for lack of knowledge and approval. But generally speaking, that's going to be rare, because if the testator knew what he was writing and what was being written for him and understood it in respect to the rest of the will, it's going to be highly unlikely he didn't know in particular of one part of the will. So, as he said there, such a curate's egg is likely to be rare. Now, there was a case in the 19th century where Lord Hathersley referred to, when dealing with the example of a beneficiary helping to draw a will, that the court might have to be satisfied about what he called the righteousness of the transaction. And that phrase tended to be repeated in a number of later cases, as if, but it was important to remember that it had no moral connotation. It wasn't for the court to decide whether or not what the testator had written was fair, but it could be misleading, this phrase, the righteousness of the transaction. And so again, Lord Justice Chadwick in Fuller and Strum thought that it should be avoided and was now of no particular use. Right.
So this is the final grounds on which you can challenge the validity of a will, that there was undue influence on the testator. It should be contrasted with inter vivos transactions where you're dealing with a will. There's no presumptions of undue influence, where gifts are made within certain relationships, and so an explanation is called for. It's not sufficient to prove that a testator was merely persuaded to change their will or to act in a certain way. What the challenger must establish is that there was the testator's free will was overborne. And finally, because of course the deceased is no longer around to tell us whether he chose freely or whether he was coerced, and there's a very high burden of proof, albeit on the civil standard, on the person who's alleging undue influence. So this is a direction to a jury in a 19th century case from the case of Hall and Hall. So all influences are not unlawful. Persuasion appeals to the affections or ties of kindred, to a sentiment of gratitude and so on. These are all may legitimately be fairly pressed on a testator. And then he contrasts that with pressure of whatever character, whether acting on the fears or hopes, or to overpower the volition without convincing the judgment, is a species of restraint under which no valid will can be made. So, in summary, there must be coercion. It's not enough for there only to be persuasion. There must be something more. So, coercion can range from actual confinement and imprisonment of someone, or violence, at the one extreme of the spectrum, to on the other hand, at the lighter end of the spectrum, where someone in the last days or hours of their life might have become so weak and feeble that extremely little pressure is required to bring about a coercion on their free will, so that if someone's so fatigued that they could just be pressured into doing anything by being nagged effectively. And then finally, sorry to dash through these, but I'm conscious of the time and I want to finish before we run out of time here. So in Edwards and Edwards in the High Court, there was a summary which is very useful to assessing undue influence. So in a case of testamentary disposition of assets, there's no presumption of undue influence. So what we said at the start about the distinction between wills and inter vivos gifts. Third, the burden of proving it is on the person who asserts it. Undue influence effectively means coercion and not mere persuasion. Coercion is, as I say, distinguished from persuasion. 6, the physical and mental strength of the testator are relevant factors in determining how much pressure is required to overbear the will. So obviously, a young, healthy individual, mere sort of nagging and keeping at them isn't likely to produce a kind of coercion. Whereas if someone's in an oncology ward in the last hours of their life and someone's just nagging at them about changing their will, then obviously that could well be coercion. And essentially, just to sum up all of this, the question is, it's number 9, the question is at the end whether in making his dispositions the testator has acted as a free agent. So to summarize that on undue influence aspect, essentially the context is pretty important, and there needs to be coercion more than just persuasion, but the individual being persuaded or coerced, their physical and mental, their physical strength and condition is an important factor in making that assessment. So then John's just going to touch on leak and newsletters and caveats, and then we will try and deal with some of the questions at the end.
Yes, if you're a beneficiary or potential beneficiary and you think that something has gone awry with the making of the will, it is possible to write what's called a Larkin letter to the person that drafted the will, usually a solicitor, asking for details of how the will came to be executed. It's very common, and it's very useful, because once you've got the replies, you will know whether or not you've got a case to mount to challenge the will itself. The final thing I want to just touch on is, again, if you think that there is a challenge to the will that can be mounted, then you will want to stop the executor distributing the estate before that challenge has been dealt with. And so what you can do is register what's called a caveat at the probate registry, and there is a procedure for dealing with caveats and answers and removal of caveats in the probate registry. But entering a caveat will at least prevent the estate being distributed while you sort out your challenge. Now, that's all I want to say about that. I will, if you wish, any of you wish, I have done a detailed paper, and these slides are based on it. And if you want to have a copy, if you would like to email Emma Williams in Chambers, I'm sure we can provide you with one. But I do go into a bit more detail in that paper of the matters that we've discussed.
Yeah, we'll try and send that out with these slides, because John's paper is extremely helpful, I think. Right, so John, we've got about 6 questions now. I think Fawid Mir has just raised his hand as well. Fawid, we can't take raised hands, but if you just pop a question in the Q&A section, we'll try and take it now.
Yeah.
So, first question from Anonymous.
Yes, money in a joint bank account.
Yeah.
Generally speaking, yes, money in a joint bank account will go to the survivor, generally speaking, unless, and that's independent of the will. There is, so a joint house held in joint names will, where there hasn't been a severance of the joint tenancy, on death, the right of survivorship applies. And so, as with a joint bank account, a house held in joint names, the deceased share goes to the survivor and doesn't form part of the deceased estate.
Great, thanks.
There may be instances where it could be challenged, where you could show that there was a different intention, either with the house or with the bank account. But the strong presumption is that the bank account and the house are held jointly, and survivorship applies.
Next question, Suzanne Gulshan. What happens if a will is made appointing a person as executor on the basis that if that person predeceases the testator, another person should act and the person lacks capacity at the date of death? Does the substituted executor need to make an application under the Senior Courts Act, or would other beneficiaries take precedence?
So I'm just trying to get my head around that, Suzanne. If you mean by the person lacking capacity at the date of death, if you mean the testator, then that doesn't matter. It's the time of the will that one has to look at the capacity, not at the date of death. But if you mean the person appointed executor lacks the capacity at the date of death, then there would have to be an appointment of another executor.
Great. All right, thanks, John. Sushil Gill, the courts have looked at periods where the testator is lucid but may still have capacity issues. In that case, is the matter tried on a case-by-case basis?
Yes, I've actually had this tried out. A case I was in, it's very common where there are periods, person in hospital, say on morphine, is in and out with perhaps delirium. It is case-by-case basis. It is at the time of the will, did that person lack capacity? It may be that the day before they were out of their head, so to speak, on morphine, but by the time they came to make the will, they might well be lucid. So it is case by case.
Great, thanks, John. Eliza Kubik asks, if there are several beneficiaries named in a will, for example, a surviving spouse and children, who would you advise to obtain a grant of probate to act on behalf of the estate in court proceedings on a personal injury claim?
Well, it would be the person named as executor who would obtain the grant of probate.
Yeah.
Say if there are several beneficiaries, I don't really mean several. If there's more than one executor, then it's all the executors.
I suspect it might be a question about where someone's died intestate and they haven't named an executor. Who would you advise to obtain?
Well, then that would be the administrator.
Yeah.
The administrator of the estate.
Yeah.
Under the rules of intestacy.
Yeah. Right. Another anonymous question. What can be done if you suspect that the latest correct will is being withheld, concealed by an executor to enable a beneficiary to benefit more favorably under an old will?
Well, you would enter a caveat, first of all, if the executor is trying to prove an old will and you think there is a more recent will, you would enter a caveat to stop the old will going to probate, and then you would have to make an application to the court to prove a formal will, but you'd have to have strong evidence that there was such a will.
Right. Yeah.
You would have to prove that there was a later will, not an older will. I'm sorry.
Yeah.
So,
quite difficult to do.
Yes. Well, it depends on your evidence.
Yeah. Right. So Lucy Evans asks, can a Larkin newsletter be used to find out information about a will which was drafted but not executed?
I've not been asked this before. No, I think would be the answer to that, because although the will is drafted, it hasn't been executed. It's not a will, and so can't be admitted to probate.
Okay, so we've got
so you'd have to wait until it was executed.
Yeah. All right, 3 or 4 more questions from Fawad Mir. Can you elaborate on point 3, challenging validity of will, letter and reg caveat, please? So I think, just to be clear, that the Larkin newsletter and caveats were unrelated to well, yes, it wasn't really about the undue influence points. It was just
it's more procedural.
Yeah.
Rather than substantive.
Yeah. And then second last question from Cecile Gill. What is the position regarding 2 parties who wish to apply for letters of administration?
Well, you'd have to, first of all, what you do is you look at the Rule 22 of the Non-Contentious Probate Rules. That sets out the list of people in order of priority who are entitled to letters of administration. So first of all, it's the surviving spouse. If there's no surviving spouse, it's other relations, starting, as I recall, with parents. So you would look at that list first. And depending where you come on that list, you would then have to, if you thought that the person entitled to apply wasn't suitable, you'd have to make an application under Section 116 of the Senior Courts Act to have that person, to have yourself appointed as administrator.
Yeah.
As I say, there have to be initially special circumstances for that. And I thought while I'm waiting for a reserved judgment in the Chancery Division on this, we had a hearing last Friday on this very point. So there have to be special circumstances, and the court has to find it either necessary or expedient to replace the person who would otherwise be administrator under the non-contentious probate rules.
And then the final question is just how attendees can obtain a copy of the extended paper of the talk that John's written. I mean, John, should we just send that out to the list of attendees by email?
We could send it out. Well, I wouldn't dare to cast it upon people who might not want it. If you want it, I suggest you email Emma Williams in Chambers.
Yeah.
And I've already, I think, sent her a copy of it. If not, I'll send her a copy anyway, and then she can pass it on to you.
Great. Okay, that's it. So just a reminder then that you've got some very entertaining speakers next week in Simon Trigger and Dominic Smith on fundamental dishonesty. As I say, Dominic is on something of a run at forum in terms of getting these findings against claimants in personal injuries matters, and Simon Trigger is a deputy judge now, isn't he? So he sees a lot of this, no doubt. And yeah, you'll get some really good insights from both of them. So it's worth tuning in. I think it's next Thursday morning as well, isn't it? All right. Thanks everyone for attending. If you had any questions that you didn't get to ask, or that we missed and you'd like a little bit more detail on, do feel free to send an email through the Chambers, and John or I will try and take a look at them and help.
Okay, thank you very much.